We put out a newsletter 3 times a year, and they're free of charge. And if you would like to sign up for it, get on the mailing list, there is a sign-up sheet over there as well, right up here in front. All right, well, we had tried to come up with a topic related to disability law, and so we gave a general, I don't know what it's called in the program, update on disability issues or something, but that was too broad, so Elizabeth Overmo and I started thinking, what can we talk about today that might be pertinent to a lot of people here? Well, this is what we came up with. Now, from time to time, our agency will get a call from somebody, usually a parent, that goes something like this. Let's see how we go. Here we go. My child was arrested for whatever. She has an intellectual disability. She's very easily manipulated or influenced, and some other kids asked her to do something, which was illegal, and now she was arrested. And she, of course, was the one who was arrested. Or maybe it goes like this. My son has a mental impairment, diagnoses of this and that, and I've been trying to get the school to provide more help for him, and the school refuses. And recently he blanked, so the school called the police and he was arrested. So then we'll ask, so does your child have an attorney? Yeah, we have a public defender, or we have a court-appointed attorney, or we have a friend who's an attorney who we contacted, but the parent says we don't think that they know a lot about disability law, or maybe not a lot about the child's disability. Can we call that attorney? And we'll respond, well, no, we can't call the attorney. We're not going to make a cold call to somebody. But if you talk to them and they would like to call us, that would be great. And then we'll discuss the situation and see if we can provide any assistance in that type of situation. So basically, a couple of questions looking at this presentation. You're representing a juvenile with a disability before juvenile court, and is that a help or hindrance to your defense? And then second, how can a juvenile attorney use the child's disability as an asset with his or her representation in a juvenile justice proceeding? Well, we don't do criminal work, but I'm thinking one of the first things I would want to know if I'm representing a juvenile is, does the child have a disability? Because that will have an effect on how I defend the case. So now sometimes that answer is going to be obvious, and sometimes it isn't going to be that obvious from looking and speaking with the juvenile. And the juvenile might not always be the best person to ask because they may not want to talk about it, they may not want to admit it, they're embarrassed that they have limitations. Some juveniles with disabilities, they want to be treated exactly like everybody else, and even though they may be getting services, they don't ever want to admit that. But usually the situation is that the juvenile simply doesn't have a lot of insight as to the limitations because they are who they are. They don't understand that they may have limitations that others don't have. So parents or guardians or maybe others might be better to ask. So then if the answer to that question is yes, the child does have a disability, then what? Well, find out if the juvenile is receiving special education services from the school district, either on an IEP or maybe if the child doesn't qualify there for a 504 plan. And I provide some explanation of what those are for those that don't know. We don't have enough time. I wish we did to go into all that. But obtain a copy of the most recent special ed programs, the IEP or the 504 plan, and any amendments. Also obtain a copy of any of the child's recent evaluations done by the school district. Sometimes there are going to be behavior plans. Obtain a copy of those if they're not part of the other documents. Also, since the child was arrested, perhaps there's been discipline problems in school, get a copy of all the recent discipline statements as well. Also, chances are that if a child has a disability, the child may be seen by some outside regular medical doctor, psychiatrist, psychologist, counselor, whatever it may be. Obtain those records as well. Now the reason for doing all this, of course, is so that you get a good handle on who your client is and what their limitations may be. Now, a lot of parents keep very good records and they can provide you all that. Other parents we found are horrible at keeping records and they can't ever find anything. So you may need to either try to get the parent to provide them or to get a release so you can obtain those records yourself. All right, now the next slide is the definition of what's an IEP and what's a Section 504 plan. I provide a lot more information on those in the outline in the attachments. I'm not going to go through those. I'm going to get to the latter part of this. This slide is just an example of sample IEP, page 1, and an amendment, page 1, and then the next slide is a sample of a 504 plan and a 504 review, page 1. Both of those documents are contained in the outline. All right. Now, what if the juvenile is not on an IEP or a 504 plan? Well, that's not unusual either because eligibility issues are sometimes very contentious with the school district. Parents may feel that the child should be receiving services, the school's denied it. That doesn't mean that the child doesn't have a disability or maybe the child should be getting services, but they're not. So even if you find that the parent says that the child has a disability, but the child's not receiving services, that doesn't mean that there aren't evaluations that have been done, either by the school or outside sources. It doesn't mean that there aren't behavior plans or discipline records within the school. So you should, in that situation, also obtain those. Now, after you receive the documents, what do you do with them? Well, the evaluation results should be very helpful to you. Some of this is pretty obvious, but the evaluation results are going to help with the defense as far as capacity to understand the proceedings, state of mind when the crime is committed, was there a disability-related issue that led to the crime, and also looking to see if the school district is addressing the child's disabilities. Because you may find that there's a gap between what the evaluations recommend and what's actually being provided to the student in the school district. Okay, so then after you receive the documents, what do you do with them? Okay, now each situation is going to be a little bit different. Is the district following the IEP or Section 504 plan? Now, to find that out, you may need to have a discussion with the parents. And then, again, are there evaluation recommendations that aren't being incorporated? Is the district following the IDEA, that's the special education law, the discipline procedures if the child is suspended? Is the school providing services in another setting? Are the recommendations from the juvenile's doctor or other outside professional that the school is ignoring or not incorporating into the child's program? And then also, is the parent currently engaging in discussions with the school district to improve the services that the child is receiving? That's important. And then also, is the parent working with our agency, South Dakota Advocacy Services, to address the educational issues? And so then, well, how does that help? This next question, okay. Well, keep it in mind that there are always a lot of factors in every case. The type of offense that's been committed will be important. That may control the situation depending on how serious it is, and also if there's a long prior record. But generally, our experience is that juvenile court judges are, as I put here, none too happy to find out that school districts have dropped the ball on the child. In other words, we've been successful in assisting attorneys with arguing essentially that if the school had done its job, the juvenile likely wouldn't have been here in the first place. And so judges may be inclined to postpone adjudication while the school issues are being addressed. We've seen that. Judges may be less inclined to adjudicate to a juvenile facility if the issues are being addressed with the school. The judge may be less inclined to adjudicate to a facility or be more inclined to postpone if the parent is working with our agency because the judge knows, okay, they're working with them to try and get things resolved with with the school or to provide better services. So in the outline, I've got a few examples of what we've done, because that'll kind of tie this together and make it a little bit clearer. That isn't on the PowerPoint. So a few examples here. We assisted a defense attorney in juvenile court. The juvenile had not been fully evaluated by the school. We told the judge that we'd like to see if the child qualifies for special education, so the judge continued the case. The child did qualify, a behavior plan was implemented, the judge monitored the progress and did not adjudicate the child to a correctional facility. In another situation, the judge was looking to place the child in a correctional facility. We were working with the parent to get the school to place the child in a more restrictive setting, which probably was recommended. And so the judge continued the case. The school placement occurred, and so the judge did not adjudicate to the juvenile facility. I believe this is the current one we have. We're working with a defense attorney right now to address the educational issues to determine if that will be a factor that the judge will consider. In another one, we testified that the school had failed to act, and the juvenile judge continued the case for a time period to work out a plan before moving forward with disposition. Unfortunately, in that case, the child then set a fire on the school bus, so that kind of threw that off. So the judge then did send that juvenile to a correctional facility. And then finally, another example, we discussed a case with the juvenile's attorney. We prepared a letter, which was then provided to the judge, and regarding the efforts that we were making to try to get the school to provide some additional services, whatever they were at that time, the judge found the juvenile guilty but ordered probation. So those are just some examples of how we worked with the attorneys that are representing the juveniles in these proceedings, and I guess that's about it, unless there are any questions. About a minute or two. There are. All right. Well,
thank you. Next up is retired Judge Timothy Johnson, who's also the state legislator.
Thank you, Stan. My name is Tim Johnson. I am the state representative. I represent District 31, which is Lawrence County. I'm in my first term. I got filed for a second, and I do not have an election this fall. I serve in the House and I'm on the Judiciary Committee as well as the Education Committee. I also chair the Interim Rules Committee. We review all the agency rules and any other agencies. This year in the legislature, there was a total of 449 bills that were filed. That's far less than many other years. There were 249 that were passed. The governor vetoed one, and we did not override that. So there was 248. You'll find those in your materials, in the table of contents that I have provided you. In the area of education this year, there were a lot of bills dealing with Common Core. Only one did pass, it was Senate Bill 94. It did not, or it left standing rather, our current standards related to math and reading, but it did provide that the State Board of Education will not enact or adopt any other standards until after July 1st of 2016. Of interest, there was one other bill. It was Senate Bill 90. That bill was strongly supported by the South Dakota Press Association and was strongly resisted by the South Dakota Athletic Association. It does require the South Dakota Athletic Association to comply with our open meeting law and with our open records law. There was some question as to whether or not the association qualified as a public body, but because of their close nexus with our school districts, it was decided that given the history of this state and trying to promote open government, that it was best to go ahead and pursue that. And so we did. In the area of judicial remedies, House Bill 1125 repealed various statutes found in our judicial remedies, which were either duplicative or outdated. Among others, it repealed SDCL 21-25, which provided without filing an action, parties could submit stipulated facts to any court, and then the court could enter a judgment thereon. With a little bit of research, it was determined that most people weren't even aware of that statute. Nobody could remember anybody ever using it. So it was repealed. The governor's office every year does submit quite a bit of legislation. They go through all of our statutes, and it's regular that we do repeal various sections of the code that are no longer used or are considered to be antiquated or duplicate of other sections. In the area of criminal law, it's now a crime for a registered sex offender to loiter in a public library. That bill was brought because there was a number of incidents throughout the state, and so it was thought that it would be best that we do that. House Bill 1229. We had a lot of gun laws, bills for enacting gun laws. There was the South Dakota Gun Owners Association that brought one that even suggested that we should allow people who had carry permits to have the gun, carry their firearms in the state capitol. They resisted this bill, although it was brought by the National Firearms Distributors Association, was supported strongly by the National Riflemen's Association. This bill provides for a system of reporting to the National Incident Criminal Background System the names of those persons who are prohibited now by federal law from possessing a firearm because they've been adjudicated by a board of mental illness as being a danger to themselves or others, number one, or number two, they've been found not guilty by reason of insanity, or number three, they've been found to be incompetent to stand trial. I like the bill. I actually sponsored it. What I liked about it particularly is that it provides for a procedure whereby persons who have been adjudicated as a danger to themselves or others may petition the circuit court for restoration of their rights, which is not allowed for at the present time. It would be a real simple procedure because once you are discharged from the hospital, you're certified as no longer being a danger. So I expect that it'll work very well. We had quite a few bills in the area of domestic relations. We have Senate Bill 74, which was supported by the State Bar Association. It's the Joint Physical Custody Bill. It requires a judge to consider any custody dispute between parents upon application of a parent that the court consider grant joint physical custody of a minor child. The enactment, I want to make clear, does not require that the parenting time be equal in duration. It doesn't have to be 50-50. It doesn't require that. It only requires that the court consider joint custody rather than placing the child with a primary custodian. The enactment also codifies various factors that courts are now considering based upon case law and other statutes. There was a summer study in 2013 concerning our statutes governing protection actions. I believe there were 6 that were submitted, 5 were passed, and I'm going to talk just briefly about 2 of them. Senate Bill 7 amends SDCL 25-10-1. It expands the concept of what constitutes a domestic relationship for domestic abuse statutes. Heretofore, domestic meant what everybody would think it means. It means anything occurring between family or household members. Now it means, or it extends it to any person who, quote, is in a significant romantic relationship, end of quote. It's going to be interesting to see how the courts deal with that one. When the bill hit the floor, it also included past romantic relationships, but we were able to amend the bill and get that out of it. It was considered that it would be a real difficulty for law enforcement arriving at scenes to deal with that issue. And speaking of law enforcement, Senate Bill 2 allows a law enforcement officer who is called to the scene of a domestic abuse complaint the discretion not to arrest a victim of domestic abuse for an outstanding warrant if that warrant is for a non-violent misdemeanor offense. If the victim is not otherwise liable to arrest for any action arising out of that incident of domestic abuse, and if the victim is the custodial parent or the immediate caregiver of a minor child. In those cases, the victim cannot be served with a warrant for the next 72 hours. The Uniform Probate Code, we have House Bill 1077, which enacted the Uniform Property Transfer on Death Act. It's a good bill, very good bill. Better move along. It does avoid some of the issues that you've had, or you may have seen in your practices, where property is placed in joint tenancy and property gets transferred. What I'm
Mike's off.
Can you hear me?
Shout it out.
We do have the social host bill that provides that no person acting as a social host may knowingly permit any underage person to consume alcoholic beverages, regardless of the source of the alcoholic beverage, under or alcoholic beverages owned by that person acting as a social host. That term includes anyone who hosts a social gathering and knowingly those use of those beverages by underage persons. And it provides that it doesn't matter whether the host is physically present or not. We have a new cause of action for bad faith assertion of alleged patent infringements. There's been quite a thing happening across the country, what we call patent trolls. This act sets forth various factors for courts to consider in determining whether it's a ban whether it's set in bad faith, and making it clear that the act does not apply to certain entities, including corporations traded on the public stock exchange, owners of those patents, which are then used in connection with either the production, manufacturing, processing, or delivery of services or products. What's interesting is if the plaintiff succeeds in one of these actions, they can recover equitable relief, they can recover damages, they can recover their costs, including their attorney's fees, and they can recover exemplary damages in an amount equal